The latest on Lori Daybell. The prosecutor has responded to Lori's request for a new trial in a 16-page document. It's pretty interesting. We also have some Kohberger news as that trial gets closer and closer to us, and a fascinating interview that I hope you will stay tuned for. Monique Smith. She's been called the longest living Jane Doe. And after years of abuse and trafficking, she finally learned, after years and years, decades of living, that she wasn't who she thought she was or who she was told she was. And then went on this incredible journey, and has been on this incredible journey to find out who she really is. We met at CrimeCon years ago, just kind of in passing in a hallway. I saw her, I grabbed her, I did a quick interview there on the spot, and I said, I need to talk to you more. And finally, that happened this week, and I hope you'll stay tuned for that interview. Lifetime actually did a movie just a few weeks ago about her story, and she's written a book called You Are the Ancestor, and it's just I think you'll find the interview really inspiring, and it will leave you with a lot of questions, as it did me. Before we get to that, though, let's talk about Lori Vallow Daybell. You remember that last week we talked about her wanting a new trial. She filed a motion for a new trial, said that there were 5 reasons why she needed a new trial: prosecutorial misconduct, juror misconduct, improper exclusion of hearsay testimony, lack of impartiality by the court, issues with witnesses and what they said. Well, Treena Kay, the Maricopa County Deputy Prosecuting Attorney, has now responded in a 16-page document. Now, I'm not going to go through it all for you tonight. I'm going to go through the key points to kind of get you up to speed, just kind of give you the highlights. Basically, Treena Kay responded and said there was no juror misconduct. There was no prosecutorial misconduct. There was no improper exclusion of evidence. And the judge was not impartial. Let's start with the juror's statement. We've talked about this a few times. I'm not going to play the statement, but one of the jurors came out of the courtroom right after the verdict was announced, and seemed to imply that he was aware of Lori's prior convictions when he said he was driving home from the court and he felt sorry for her, thinking she'd be spending the next 3 lives in prison. Treena Kay, that was the reason number 1 why Lori said, I deserve a new trial, because the jurors were not supposed to know about her previous convictions. Fair point, because they weren't. However, Treena Kay responded and said, that wasn't the only statement the juror made that day. 1, the juror was ambushed with media, and they referenced video from other media outlets saying that the cameras were running up to them. They were likely confused, caught off guard, understandable. But then she said this juror also was asked, and I was there in the scrum when this happened, were any of you folks aware that this woman had already been convicted of 3 homicides? And juror 15 responded, No, I did not. Meaning he didn't know. He goes on to say that this juror did another interview where he was asked repeatedly and stated repeatedly that when he was in the jury room, he started Googling Lori Vallow. He spoke with Hidden True Crime, the Hidden True Crime podcast, and said that when he was in that room, that's when he started to Google Lori Vallow and was asked. And so it sounds like before he even walked outside, the juror had Googled it and knew. Basically, Treena Kay says, no juror misconduct there. He's fine. That reason should be dismissed. Daybell also raised concerns and was upset that statements that Tylee made and Alex Cox, her brother, made to police right after Charles Vallow was shot were not admitted into court. They weren't admitted because they were hearsay, because those 2 were not alive to authenticate that they said those words. They couldn't take the stand as witnesses. Treena Kay wrote, there's no exception that permits their admission. The defendant never established a foundation that any statements made by Alex or Tylee hours after the shooting were admissible under any of the Arizona rules of evidence. The testimony of Alex Cox and Tylee Ryan were appropriately precluded or excluded as hearsay. Statement number 2, knocked out. Or responded to. Treena Kay then responded to allegations that she committed a discovery violation by not turning over a hard drive with Charles Vallow's cell phone info to the defense until the middle of the trial. Remember, that was an issue that came up. Lori's team couldn't get into to evaluate the data, and it went back and forth, and ultimately Treena K noted that the judge, Beresky, told Lori, do you want a continuance? We can delay your trial if you need more time to evaluate all this evidence. And Lori said no. Quote, the defendant advised she wanted to proceed with trial and said, instead of seeking a continuance, to allow her expert time to review the victim's cell phone. Lori could have had more time to do that, but she didn't choose to, according to Treena K. Not only that, Treena K says that evidence, the issue that was discussed with the cell phone and Charles Vallow and everything, that was disclosed to her team in January of 2024, more than a year before the trial started. So the issue of timing, Treena K says, isn't an issue. There was no, issue with the evidence. Daybell accused Treena K of committing prosecutorial misconduct by giving false statements during her closing argument. K responded to Daybell and said, excuse me, I gotta wipe my nose. I don't have a tissue nearby. I'll wash my hands, I promise. Kay responded that Daybell, quote, intentionally mischaracterized one sentence from her entire closing argument. The state I'm quoting here, the state made argument to the jury regarding the defendant's demeanor on the day of the shooting. The witness described the defendant as chatty, nonchalant, and unaffected by her brother allegedly being struck with a baseball bat, her husband lying dead in the house, and her children no longer having a father. Treena K stressed Lori was nonchalant during all of this. The defendant's demeanor with law enforcement the day of the murder was in complete opposition to the defendant's demeanor during opening statements when she was crying in front of the jury. So, Treena K responds to that allegation from Lori. Another reason that Daybell said that she deserved the new trial was because Beresky struck two of her proposed witnesses, me and Brandon Boudreau. Do you remember that this was an issue in the beginning of the trial, that Lori wanted to call me as a witness? Beresky, I had my attorney go up and say that I shouldn't be a witness. I prepared a document. Beresky told Lori, I'm going to strike me from the witness list, but if it comes up later in the trial that there is a valid reason why Nate Eaton needs to testify, I will reconsider it. Same with Brandon Boudreau. He was excluded from the list without prejudice, meaning if Lori Vallow Daybell made a valid argument that he should be called to testify, the judge would consider it. Well, Lori ended up not calling any witnesses, and our names were never brought up again until this motion, when Lori's saying that the judge unfairly excluded us from the lists. As far as an issue that Daybell raised concerning Beresky making being an impartial judge because he made a statement when she was questioning someone about Nephi and translated beings, Kay responds, the defendant argues that one comment by the judge during a 2-week trial somehow rises to the level that the judge was biased or prejudiced. Defendant has not shown any level that she was denied a fair trial because of an impartial judge. So that is a brief 3-minute synopsis of Lori's filing, the response to Lori's filing from Treena K. The judge, I expect, will rule on this. He might hear an oral argument. It's up to him. What we do know is that next week on the 14th, there is a pre-trial hearing before the trial starts. I just can't believe it. We're already to trial number 2. Trial number 4, really. Trial number 2 in Arizona. So we'll see if the judge responds in writing to her request, denying it or approving it. If he approves it, we'll obviously have one more trial. I don't personally expect that, but I could be wrong, and I'll tell you if I'm wrong. And then the hearing set for next week, we'll discuss maybe some other motions. So we will have that for you next week on the 14th, next Wednesday. It won't be live. The judge has put in a delay. As soon as we can get the video from our friends in Phoenix, we will have that for you. And then we will do a Courtroom Insider next Wednesday, not Thursday. So join me next Wednesday night at 8 o'clock Mountain Time, and we will have Courtroom Insider.